guys! Welcome back to my channel. So for today's video, we are going to talk about Article 18 of the revised Penal Code. So Article 18 talks about accomplice. So accomplice are the persons who, not being included in Article 17, cooperate in the execution of the offense by previous or simultaneous act. So let's talk about first quasi-collective criminal responsibility. So in my previous video, Article 17, which talks about principles, I mentioned their collective criminal responsibility and individual criminal responsibility. So in between collective criminal responsibility and individual criminal responsibility, there is also what we call collective criminal responsibility, quasi collective criminal responsibility. So in quasi collective criminal responsibility, some of the offenders in the crime are principals and the other are accomplices.
So sa quasi-collective criminal responsibilities, mix siya be. So, may principal and at the same time, may accomplice din. So,
the participation of an accomplice presupposes the commission of the crime by the principal by direct participation. So that the principal element of every punishable complicity consists in the concurrence of the will of the accomplice with the will of the author of the crime. This is under the case of People versus Tamayo, and the accomplice cooperate by previous or simultaneous acts in the execution of the offense by the principal.
So, here, dapat may intention or will on the part of the principal, then at the same time, meron din sa accomplice. Pero yung cooperation niya is by means of previous or simultaneous as in the execution of the offense by the principal. So, we are going to understand accomplice in this video. So, magsimula muna tayo. Hihimay-himay muna natin to ng mabuti kasi medyo nakakalito itong accomplice, no? So, Article 18, accomplice. So, let's start with the first phrase. Accomplice are the persons who not being included in Article 17. Not being included in Article 17. So, by the way, before you watch this video, I highly recommend that you should watch my previous video about Article 17. Mataas-taas yung video na yun, be, kasi grabe yung explanation ni Luis B. Reyes dun, be. So, grabe yung video ko, mataas dyan. Ulit-ulit. So, I highly recommend that you watch that first before you watch this accomplice. Kasi sabi dito sa accomplice is, ang accomplice ay yung mga tao na hindi na-include under Article 17. So, kung hindi mo alam kung sino yung mga tao sa Article 17, so, hindi mo talaga ito maiintindihan. So, dapat, palagi ako nagsasobe, no? So, dapat mapanood mo muna yung Article 17.
So, not being included in Article 17, but the participation or cooperation of the accomplice is not any one of those mentioned in Article 17, which defines the three concepts of principles. An accomplice does not fall under any of the three concepts defined under Article 17, which is cited in the case of People versus Ubina. So when there is no conspiracy between or among the defendants, but they were animated by one and the same purpose to accomplish the criminal object, those who cooperated by previous or simultaneous acts but cannot be held liable as principals are accomplices. So, in case of doubt as to whether principal or accomplice, the participation of the offender will be considered that of an accomplice rather than of a principal.
So, yun, no? So, kung saan yung may lesser responsibility or kung saan yung may lesser penalty is yun yung pipiliin. So, pag may doubt kung ang isang offender or isang accused is principal ba or accomplice, so yung pipiliin is accomplice since yung accomplice is may lesser responsibility siya.
So, where there is doubt as to whether accused acted as principal or as accomplice, accused should be held liable only as accomplice. So, mere presence at the scene of the incident, knowledge of the plan, and acquiescence thereto are not sufficient grounds to hold a person a conspirator, lacking of sufficient evidence of conspiracy and there being doubt as to whether appellant acted as a principal or just a mere accomplice, the doubt should be resolved in his favor and is thus held liable only as an accomplice.
So again, pag may doubt or may duda or walang evidence kung siya ba ang principal talaga or ano or accomplice lang, so yung pipiliin is yung may lesser responsibility, which is an accomplice.
So, when the participation of an accused is not disclosed, he is only an accomplice. So, a person who assists one who commits the crime of arson and who knows the latter's purpose, but whose participation in the arson is not disclosed, may not be considered as a principal because his acts are neither direct nor absolutely necessary for the commission of the offense, nor do they induce the said commission. So in criminal cases, the participation of the accused must be established by the prosecution by positive and competent evidence. It cannot be presumed.
So dapat may evidence talaga no na yung participation ng accused is dapat may evidence na ma-establish na yung accused is nag-participate talaga. Hindi siya pwedeng i-presume, no? Kasi liberty yung nakataya dito. Kaya dapat may matibay na evidence. Hindi dapat presumption lang, ganun.
So, an accomplice does not have previous agreement or understanding or is not in conspiracy with the principal by direct participation. So, an accomplice does not enter into a conspiracy with the principal by direct participation. He does not have previous agreement or understanding with the principal to commit a crime, but he participates to a certain point in the common criminal design. This is cited in the case of People versus Aplegido. So if there is conspiracy, all the conspirators are equally liable for the crime actually committed by any one of them. The same penalty shall be imposed on each and every one of them. So on the other hand, the accomplice gets a penalty 1 degree lower than that provided for the principal in the consummated felony. So
dapat walang previous agreement, walang previous understanding, or walang conspiracy na nagaganap sa principal by direct participation at ng accomplice. Kasi kapag meron, hindi na siya magiging accomplice, magiging principal na siya kasi may conspiracy na nagaganap. And as we may know, yung accomplice or kapag accomplish ka ng isang crime, yung penalty mo is 1 degree lower than those of the principal. So, pero kapag nag-conspire kayo, so parehas kayo ng penalty kasi an act of one is an act of all. So, kung ano yung penalty ng iba, so yun yung penalty mo kasi yun yung sa conspiracy. Ganun yan.
now let us proceed to the requisites of accomplice.
So, paano paano mo masasabi ng isang tao ay accomplish siya? So, dapat may mga requisites tayo, no? Na kailangan sundin or alamin.
So, in order that a person may be considered an accomplice, the following requisites must concur. So, we have 3 requisites. So, the first one, that there be community of design. That is, knowing the criminal design of the principal by direct participation, he concurs with the latter in his purpose. Second one is that he cooperates in the execution of the offense by previous or simultaneous acts with the intention of supplying material or moral aid in the execution of the crime in an efficacious way. And then the last one is that there be a relation between the acts done by the principal and those attributed to the person charged as accomplice. This is cited in the case of People versus Tamayo. So let us first go to the first requisite, which is that there be community of design, that is, knowing the criminal design of the principal by direct participation, he concurs with the latter in his purpose. So in the first requisite, we must note that before there could be an accomplice, there must be a principal by direct participation. But the principal originates the criminal design. The accomplice merely concurs with the principal in his criminal purpose.
So, bago bago magkaroon ng isang accomplice, guys, again, this is the first requisite. So, bago magkaroon ng isang accomplice, dapat mayroon muna principal by direct participation. And this person, which is held to be a principal by direct participation, sa kanya nag-origin, sa kanya nanggaling yung plano or agreement ng crime na gagawin or paano gagawin yung crime na yun. So, sa kanya nanggaling yun. And then, yung accomplice is nag-agree lang siya sa decided na plano or agreement na tapos nang mag-decide yung principal by direct participation. So, si accomplice is nag-agree lang siya. So, this is the first requisite. So, dapat may roong tao which is held to be as principal by direct participation. Ganun yan.
So the cooperation which the law punishes is the assistance which is knowingly or intentionally given and which is not possible without previous knowledge of the criminal purpose.
And ito rin is dapat, under sa first requisite, is dapat may criminal purpose or may criminal design at alam ng accomplice yun. Kasi yung pinaparusahan ng ating law dito sa accomplice is yung pagtulong mo by giving moral aid or yes, by giving assistance, nag-a-assist ka sa principal ng crime. So, ito yung pinapunish dito. So, meaning, dapat yung accomplice is knowledgeable siya sa criminal act or purpose na gagawin ng isang principal ng crime. Okay?
So, example is the sentry improperly permitted certain convicts to go out of jail accompanied by the corporal of guards. The convicts committed robbery was the sentry on an accomplice in the crime of a robbery committed by the convicts. It was held no. When the sentry permitted the convicts to go at large, the sentry had no knowledge of their intention to commit any crime. This is cited in the case of US versus Bello.
So, dapat may knowledge siya pag commit ng crime. Kasi kapag walang knowledge, so walang accomplice, diba? So, kasi paano ka mag-a-agree kung wala kang knowledge? So, yun.
So, but the driver of the taxi cab who knowing that his co-accused were going to make a hold-up permitted them to use the taxi cab driven by him in going to the store where his said co-accused staged the hold-up and waited for them until after the hold-up is an accomplice of the crime of robbery. This is cited in the case of People versus Lingtad. So how do we determine how an accomplice acquires knowledge of the criminal design of the principal? So to answer this question, so I have made a separate video for that and I will also write it down in the description. Bakit hindi ko na siya sinali kasi para hindi na masyadong mataas itong Article 80 natin. So, you might want to check it out, guys. Okay, that is very relevant for this video. Now, let's go to so the accomplice intends by his act to commit or take part in the execution of the crime. So, basahin nyo na lang yung case ni Carino versus Peoples for this statement, no? So, hindi ko na siya i-discuss or hindi ko na siya babasahin ito kasi it's very, very, very mataas. So, now let's go to community of design. So, which is also stated in the first requisite. So, in this case, the accused facilitated the commission of the crime by providing his own house as the venue thereof. So, his presence throughout the commission of the heinous offense without him doing anything to prevent the malefactors or help the victim indubitably show community of design and cooperation, although he had no direct participation in the execution thereof. Accused is guilty of accomplice in the crime of rape with homicide. This is cited under the case of People versus Maliao. So when the owner of the gun knew that it would be used to kill a particular person and the principal used it to kill another person, the owner of the gun is not an accomplice as to killing to the other person.
So itong statement to is, for example, ikaw yung nagmamay-ari ng gun and nagpahiram ka sa isang tao na alam mo na papatay niya. For example, yung isang tao is si B. At alam mo yung intention ni B is papatayin niya si A. So, ikaw, si C, nagpahiram ka ng gun, ng baril mo kay B, knowing that B wants to kill A. But then, unfortunately, si B, hindi niya napatay si A. Which is, si E yung napatay niya, so ibang tao. So, ikaw na nagpahiram humiram ng gun, knowing the purpose of it is killing A, tapos at the end of the story, no, si E pala yung napatay niya, so you are not an accomplice of the crime. So, ganun. Kasi wala ka knowledge. So, dapat may knowledge ka sa criminal purpose or criminal design or para saan gagamitin yung baril or yung taxi cab mo para sa robbery, ganun. So, dapat knowledgeable ka. So, yun.
Now, let's go to the second requisite. So, what is the second requisite? So, second requisite is that he cooperates in the execution of the offense by previous or simultaneous act.
Previous means prior acts or before, yung mga acts or mga, yung mga ginagawa mo before. And then simultaneous is yung sabay-sabay. Yung ba, example, si principal na pumatay siya. And then, you at the same time, while principal of the crime is killing, ganyan-ganyan, ikaw rin may ginagawa kang iba. Parang ganun. Yung simultaneous acts. Yung parang sabay-sabay na acts. Yung ganun. Prior and simultaneous acts. So, yun.
Acts with the intention of supplying material or moral aid in the execution of the crime in an efficacious way. So, this is the second requisite. So, excuse me. So, like the principle by cooperation under paragraph 3 of the Article 17, the accomplice cooperates with the principal by direct participation, but the cooperation of the accomplice is only necessary, not indispensable. However, if there is conspiracy between two or among several persons, even if the cooperation of one offender is only necessary, the latter is also a principal by conspiracy. The nature of the cooperation becomes immaterial. So
sa second requisite, mga guys, yung cooperation ng isang accomplice is hindi siya indispensable. Meaning, kapag hindi siya nag-cooperate, makukumit pa rin yung crime. So, meaning, hindi siya gaano ka-importante or hindi siya masyadong important ba, ganun-ganun. Unlike, kasi kung important siya, hindi na siya magiging accomplice, magiging principal na siya under paragraph 3 of Article 17, which is principal by indispensable cooperation. So, meaning, again, yung participation ng accomplice is not indispensable to the point na maaari pa rin ma-accomplish yung certain crimes or felonious acts na pinaplano lang kahit wala siya or kahit hindi siya mag-cooperate. So, yung participation ng accomplice is hindi indispensable but it is only necessary. Pero, kung ang participation niya is necessary, though hindi siya indispensable, necessary lang, is may conspiracy na nagaganap. So, we cannot that person cannot be held as accomplice but a principal as conspiracy. And then the nature, yung nature niya yung nature na cooperation na ginawa niya is immaterial. So again, even though hindi is indispensable, pero pag may conspiracy na gaganap, principal yon kasi the act of one is the act of all sa conspiracy, di ba? So, yung nature ng kanyang cooperation or pag-cooperate sa kanyang crime is immaterial na, magiging immaterial na. So, yun.
So, let's have examples of cooperation by accomplice. So, by accomplice, by previous act. So, ito yun, di ba? Previous or simultaneous act. So, yun, di ba? Sa second requisite. So, let's have a example for previous act. So, the example of cooperation by previous act is the lending of the dagger or pistol to the murderer, knowing the latter's criminal purpose. So, in the crime of rape, the premises who, knowing the criminal purpose of another, furnishes him the drug with which we will put his victim to sleep in order to rape her is also an accomplice in the crime. This is cited in the case of US versus Flores. So,
ito yung example ng mga crimes or previous acts na ginawa. So, ito yung pagtulong or pag-aid mo sa isang principal ng crime. So, example nito is the first one is kapag nagbigay ka ng dagger, nag-lend ka ng knife, which you know that knife will be going to, will be an instrument for killing someone, ganun-ganun. And then the second one, if you are a pharmacist, tapos ikaw mismo yung nag-aid or nag-give ng assistance sa gamot na ipapainom sa isang dalaga para ma-rape siya. So, you are an accomplice of that crime. So, yun.
Now, let's go to example by simultaneous act. So, the defendant, so,
itong previous act is before acts, diba? So, for example, nag-lend ka ng knife. So, hindi pa naman na-execute yung crime, diba? So, yun yung before act mo. And then, ito yung simultaneous means sabay-sabay, meaning, while a principal is doing something, meron ka rin, kasabay nun is meron ka rin acts na ginagawa.
So, the defendant who held one of the hands of the victim and tried to take away the latter's revolver while his co-defendant was attacking him is an accomplice, for he cooperated in the execution of the crime by simultaneous act without any previous agreement or understanding with his co-defendant. This is cited in the case of People versus Estaro. And then another example is that the three persons who actually detained and offended woman were principals in the crime of illegal detention, and the three other accused who held the victim's companion in order to prevent the latter from rendering any help from the victim were accomplices, there being no conspiracy among them. People versus Crisostomo.
So here's a simultaneous act. We must know na dapat walang conspiracy na nagaganap. So, example nito is kapag may murder na nagaganap, tapos ikaw nagawak-hawak ka, nagtulong ka sa paghawak ng tao. So yun. So while yung principal is busy siya kung paano papatayin o babarilin ba niya, ikaw naman busy ka rin sa paghahawak ng victim. So yun. Simultaneous act. So yun yung example.
So, the cooperation of an accomplice is not due to conspiracy.
So meaning, yung pag-cooperate ng isang tao na which is held as an accomplice is hindi dahil sa conspiracy or hindi dahil may previous agreement sila. So yun. Naintindihan nyo ba? I mean, again, so yung cooperation ng isang accomplice, ang reason nun ay hindi dahil sa previous agreement or decision na ginawa nila. So, walang conspiracy. So, again, walang conspiracy na gagawin kasi kapag may conspiracy, again, paulit-ulit, it would not be held as an accomplice but as a principal na siya.
So, when the acts of the accused are not indispensable in the killing, they are merely accomplice.
So, kapag yung acts ng isang tao is hindi masyadong importante to the point na kapag hindi siya nag-operate, wala sanang criminal or felonious act na nagawa, or kapag hindi siya nag-operate, hindi sana magiging successful yung felonious act na pinaplano nila, yun yung is indispensable. So, hindi masyadong importante. So, kapag yung acts ng isang tao is not indispensable, hindi masyadong importante, so yung tao na yun na nag-operate will just be held as an accomplice, not as a principal. So, yun nga.
So, the accomplice merely supplies the principal with material or moral aid without conspiracy with the latter.
So, yung accomplice is nagbigay lang siya ng aid, assistance, moral support, ganon, or nagbibigay siya ng material. Kagaya ng example ko, like nagbigay siya ng poison or medicine, if you're a pharmacist, nagbigay ka ng poison or nagbigay ka ng baril, ganon. So, yun yung act ng accomplice. So, nag-supply lang siya ng mga kailangan ng principal. So, parang aid lang ba? Moral support, ganon. But, his act is not actually necessary kasi even though hindi siya magbigay ng ng gamot, ganon, the principal of the crime can get those things in some other places. Tama ba yung English ko? So, even though hindi siya nag-operate, makukuha ng principal or maggagawa ng idea yung principal kung saan niya makukuha yung material na yun. So, meaning, makukumit pa rin yung crime. So, hindi siya indispensable, diba? So, yun.
So, the wounds inflicted by an accomplice in crimes against person should not have caused the death of the victim.
So, meaning sa accomplice, yung wound niya, example, pag may na-inflict siyang wound sa victim, hindi masyadong major. So, minor lang mga besh. Ang ibig sabihin is, hindi siya, yung injury na nabigay niya sa injured person or sa victim is hindi yung reason ng pagkamatay ng victim. So, meaning, minor wounds lang siya. So, kasi kapag siya yung reason ng pagkatsugi ng victim bash, so hindi ka na-accomplish, principal ka na ng crime na yon. So, yun. So, we have example cases, for that scenario. And I also did make another video for that. So, you might want to check it out. Again, I'll just write it down in my description box below. So, kapag, again, yung accomplice, yung na-inflict niyang wound or injury sa other person is minor lang, hindi major. So, yun yung tatandaan natin, be.
So, now let's proceed to being present and giving moral support when a crime is being committed will make a person responsible only as accomplice in the crime committed. So, absent knowledge of criminal purpose of the principal giving aid or encouragement, either morally or materially in the commission of the crime, mere presence at the scene of the crime does not make an accomplice.
So yun. kapag wala kang knowledge sa criminal purpose ng offender but you gave something or you encourage or you give something for encouragement or ganun-ganon, materially or morally, you are not liable. Kasi again, dapat may knowledge ka sa crime na ikukumit ng isang tao para ma-held ka na liable ng accomplice. Kung wala kang knowledge, so you cannot be held as an accomplice, darling.
So, moral aid may be through advice, encouragement, or agreement.
So, ito yung paano ka makabibigay ng moral aid or moral support. So, bibigay mo yan through advice, encouragement, or agreement.
So, but the complicity which is penalized requires a certain degree of cooperation, whether moral through advice, encouragement, or agreement, or material through external acts. So, in the case of Romana, there is no evidence of moral or material cooperation and none of an agreement to commit the crime in question. Her mere presence and silence, while they are simultaneous acts, do not constitute cooperation, for it does not appear that they encourage nor nerve her co-accused Martin to commit the crime of arson. So her failure to give alarm being a subsequent act does not make her liable as an accomplice. So this is cited under People versus Silvestre and Atienza. So the responsibility of the accomplice is to determine by acts of aid and assistance either prior to or simultaneous with the commission of the crime, rendered knowingly for the principle therein, and not by the mere fact of having been present in its execution, unless the object of such presence was to encourage the principle or to apparently or really increase the odds against the victim. Such an intent concurring with some overt act must specifically shown by the evidence of the prosecution. This is cited in the decision of the Supreme Court of Spain, cited in the case of U.S. versus Guevara. But the advice, encouragement, or agreement should not be the determining cause of the commission of the crime by the principal by direct participation. Otherwise, the one who gave the advice or encouragement or the one who entered into agreement would be a principal by inducement. When the accomplice gives an advice or encouragement to or enters into an agreement with the principal, he knows the principal is going to commit the crime. So, yun.
So, ang ibig sabihin nito is yung responsibility ng accomplice is to be determined by giving assistance. Yun bang nagbibigay lang siya ng assistance, moral support, or ganun-ganon sa principal. And also, the advice, encouragement, and agreement na ibibigay ng isang accomplice must not be the determining cause of the commission of the crime. Meaning, determining cause of the commission of the crime, meaning, yung advice niya yung naging cause kung bakit ginawa ng offender yung crime na yon. So, dapat hindi. Yung advice niya is dapat hindi maging cause kung bakit ginawa ng offender yung crime. Otherwise, if that happens, he cannot be considered as accomplice anymore because he will fall under the second paragraph of Article 17, which is principle by inducement. So, dapat yung advice niya is hindi maging cause kung bakit na-commit yung crime ng offender. Ganun.
So, let's go to the third requisite. So,
yun yung second requisite mga guys. So, third requisite is, wait, where is the third requisite?
So, the third requisite is that there be a relation between the acts done by the principal and those attributed to the person charged as accomplished. So, there must be a relation between the criminal act of the principal and the act of one charged as accomplished.
Dapat may relationship yung act na ginawa ng principal at yung act na ginawa ng accomplice. Yan.
It is not enough that a person entertains an identical crime design as that of the principal. There must be a relation between the criminal act of the principal by direct participation and that of a person charged as a accomplice.
So, dapat may relationship yung dalawang act. So, example dito is yung case ni People versus De La Cruz. So, Kayo na lang magbasa ng case na yun, guys, okay?
So, an accomplice may be liable for a crime different from that which the principal is committed.
So, pwede pala maging liable yung accomplice kahit ng different crime dun sa crime na ginawa ng principal. So,
number 1, example is the case of People versus Barbera. So, A attacked B with tertiary, the attack being sudden and unexpected when B was mortally wounded. C, a father of A, appeared, placed himself upon B's abdomen, and held his hands. Later, D also appeared and held both knees of B. C and D made it possible for A to search the body of B for the latter's revolver. It was not shown that C and D knew of the manner A attacked B. That they knew was that A had unlawfully attacked and wounded B. It was held that A was guilty of murder qualified by tertiary under Article 248, where C and D were guilty as accomplice in the crime of homicide. Article 249 and Article 62 paragraph 4 provides that the circumstances which consist in the material execution of the act or in the means employed to accomplish it, among them being tertiary, shall serve to aggravate the liability or qualify the crime only of those persons who had knowledge of them at the time of the execution of the act of their cooperation. So, ayun yun. That's all. That's all you need to know about accomplice.
So, for summary, so para ma-held ang isang tao or para ma-declare ng court ang isang tao as an accomplice, he or she must comply 3 requisites. So the first one is that there should be community of design, that is knowing the criminal design of the principal by direct participation, he concurs with the latter in his purpose. So meaning yung si accomplice is may knowledge siya about the criminal purpose or intention or felonious act na gagawin, which was designed by the principal by direct participation. And then si accomplice, we must also need to know that accomplice, hindi siya part ng decision-making agreement ng plan. Kasi walang conspiracy na nagaganap dito sa accomplice. Si accomplice is, nalaman niya yung plano after those principals or conspirators na mag-decide or maggawa ng agreement. And then, itong si accomplice, nag-agree lang siya sa decision na yon. So, yun yung first requisite. And the second requisite is that he cooperates in the execution of the offense by previous or simultaneous acts with the intention of supplying material or moral aid in the execution of the crime in an efficacious way. So, nag-participate dito si accomplice prior or simultaneous sa acts through giving aid sa principals, no? Through giving, through supporting him, advising, or ganon-ganon. Or alike. And then the third one is that there be a relation between the acts done by the principal and those attributed to the person charged as an accomplice. So, dapat yung dalawang kilos niya, yung principal at accomplice, is dapat may relationship. May relation. So,
yun guys, yun lang. And did I miss something? By the way, wait. So I also make a video about distinguishment, yes. Distinguish accomplice from principal in general, distinguish accomplice from principal by cooperation, distinguish an accomplice from a principal by direct participation. Yung mga distinction ng mga bagay-bagay na yon, I make a separate video for that, and all those video related for Article 18, I will just write it down in the description box. So, thank you so much for watching, guys. I hope you learned something today. I hope you understand my explanation, even though most of this video is reading lang. So, thank you so much. Bye-bye.